James A. Edwards, Chief Judge, presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, this honorable court. Please be seated.
Well, good morning, everybody. Welcome to a session of oral argument here before the 5th District Court of Appeal. I've been introduced. My name is James Edwards. I'm the Chief Judge. To my right is Judge Scott Makar, and to my left is Judge Jordan Pratt. We have a civil case and a criminal case this morning. For both sides, you get 20 minutes per side. If you're not familiar with our system, we have what look like traffic lights. When you're in the green, you can keep arguing. When you get to yellow, that means for the appellant, you're into your rebuttal time. And when you get to red, that means it's time to sit down. So if you have noisemakers, anybody in the audience, please turn them off or put them on silent because they're guaranteed to go off at the wrong time. We'll call our first case, which is Luis Ramos Figueroa versus State of Florida, case 24770. And for the appellant, typically we reserve 5 minutes for rebuttal. If you want something different, just tell us.
That's fine.
Okay?
Good morning. May it please the court, opposing counsel, Michelle Walsh on behalf of Luis Ramos Figueroa. I'm going to be focusing on issues 2 and 3 of the initial brief. Issue 2 involves the court's abuse of discretion in admitting photographs of the internal organs of the victim during the medical examiner's testimony in this case. The test for admission is relevance, but relevance is defined as touching on a material fact that is in dispute. In this case, you
could stand just a little closer to the microphone or pull it toward you. Thank you.
Relevance is defined as touching on a material fact in dispute. In this case, the state's argument is that the photos were introduced to provide a clearer understanding of the victim's injuries. However, the manner and cause of death and the trajectory of the bullets were not at issue in this case at all.
Had the defendant stipulated to that?
I don't recall, Judge, if the defendant explicitly stipulated to it, but there was no cross-examination on that subject during the testimony of the medical examiner. There was no.
The question was, you don't know whether the defendant stipulated?
I can't recall, no.
And you're saying it wasn't necessary in your brief, basically. It wasn't necessary to put that in order to obtain a conviction?
It wasn't necessary. That's not the test. Whether it's necessary or not, it's relevance. But it wasn't in dispute, and that has a bearing on what the relevance of it.
It wasn't in dispute, but you don't know if you stipulated to it. Didn't the state have to prove the cause of death?
The state had to prove that the victim had died. That's part of the first-degree murder elements. But whether the internal organs were damaged or not was not an element of the offense. So the state's testimony or their position at trial that it was relevant to introduce these photographs to show the victim's injuries was really not necessary because there was no question as to that. It's kind of common sense that if a bullet goes through a body, the organs will be injured in the process. And the medical examiner testified in the hearing outside of the jury's presence that he could explain the damage to these organs without reference to the photographs.
But he also said that it would assist him in describing the injuries, didn't it? Didn't he?
He testified that it would assist him. However, for example, in Hoffer versus State, which we cite, the court ruled that it was error to introduce the photograph in question of the autopsy because the medical examiner could have simply testified the victim had a bruise on the left side of his head. In the same way, the medical examiner here could have simply said, these organs that produce life-saving functions for the human body were damaged and stopped functioning in their proper way. And
but again, the test isn't whether the witness could have, through testimony, established a fact. The test is whether the photographs are relevant and not unduly prejudicial, right? So, I mean, under your theory of the case, how could the state ever introduce photographs where the death of the victim is not at issue?
They wouldn't have to introduce photographs, Judge, of the internal organs. There were photographs introduced of the autopsy here. There were photographs of exit wounds, entrance
I'm just trying to
wounds.
tease out the logic of what you just said, because, I mean, if, it's always the case that a medical examiner can testify that somebody died and testify as to the cause of death and the extent of the injuries. And if that alone is sufficient to warrant the exclusion of photograph evidence, I'm struggling to see how the state in a prosecution for a murder is ever going to be able to introduce photographs, right?
I think that they'll always be able to introduce photographs when it's an issue that's material and that's in dispute. And I know that, we've already been over the stipulation, but there were 7 questions on cross-examination. None of them that had anything to do with challenging whether the victim was alive or dead and whether his internal organs failed. These are questions
Your
that...
client pleaded not guilty, right?
What's that?
Your client pleaded not
He
guilty,
did.
which put at issue all of the elements of the crime
It
with
does.
which he was charged.
It does.
And the state had to establish through evidence all of the elements of the crime with which they had charged your client, right?
That's true, Your Honor, but it's a weighing test. You're weighing the probative value versus the prejudicial impact of the photographs. So
How is this so unduly prejudicial? How did this deprive your client of a fair trial? He didn't shoot the man.
he didn't shoot the victim, Judge, but this is State's Exhibit number 86. This is the internal organ of the victim. It's not even recognizable as an organ. It's the larynx, the esophagus, the stomach attached to this organ. This is a visceral reaction when you see this. And the state asked the medical examiner to stand up and hold this picture in particular up to the jury while he was testifying.
The fact that it's not recognizable, though, doesn't that cut against prejudice, right? Because typically, a photograph that shows, the identifiable victim, that can be seen as more prejudicial, right, as opposed to the sort of the clinical photograph of the actual injured organs. I'm
going to disagree with you, Judge, because the fact that this is an internal part of the victim's body, this is what is left of him, it's gruesome. I think it's not unreasonable to argue that somebody could look at this and feel nausea, disgust, anger, feel inflamed, feel sympathy for the victim who was young. This is the next photo. This is State's Exhibit number 88. This is the kidney and the spleen just laid out. And this is the third photograph, the lungs.
So we've seen it. So.
With discoloration. So the reason why courts are careful with visual evidence as opposed to testimonial or auditory evidence is because it has a lasting impact. It has a lasting effect. You see it. And in this case, it wasn't used as a demonstrative aid. It went back with the jury. The reason why the state can't prove, and the state has the burden of proving beyond a reasonable doubt, that the introduction of this photograph didn't impact or contribute to the verdict is because precisely the evidence of guilt in this case was very far from overwhelming, very far from copious. You had to infer a lot of things to get to guilt on this case.
Let's talk about the circumstantial evidence. In the initial brief, which I take it your colleague prepared rather than you, is that correct?
We both worked on it.
Okay. You refer to the special standard of proof for circumstantial cases. That rule was abrogated in 2020, yet in your initial brief, you acted like it was still good law. Can you explain that to me?
Yes, Judge. So I made a mistake there was a case called Davis that's in the initial brief that I had looked at that didn't have, a lot of the cases that percolated from the original decision didn't have red flags. So we made that mistake and corrected it on the reply brief and acknowledged that the standard is competent substantial evidence. It has changed.
Y'all cited to state versus law, didn't you, in your brief?
I would have to double check, Judge.
Okay, well, before you get back up for rebuttal, make sure you do, but
Okay.
I'm fairly sure that you did, and in that it has a key cite that says negative treatment abrogation recognized by Stevens versus state.
State versus law is the Supreme Court case?
Yes.
Yes, so I believe that was contained in the Davis opinion while I was doing the research. So that was absolutely my mistake, 100%.
So that's something, again, this is not new law, this is 5 years old,
Right, I understand, Judge.
before this crime even happened, so,
Yeah.
go ahead, thank you.
So with regard to the evidence in the case. You had to infer guilt in this case. The defendant had given a statement to the police for an hour and a half and made all kinds of admissions. He was 16 years old at the time. He made admissions to engaging in a drug transaction. He made admissions to tampering with physical evidence. At no time did he admit that when he left his apartment to enter the victim's vehicle and engage in the drug transaction, that he had an intent to participate in a robbery. At that point in time, he told the detectives, I had canceled any agreement that he had reached with Martaz Sugar, the co-defendant. He had canceled by that time.
Couldn't the jury infer from conduct to include, speaking with the victim during the time that the co-defendant opened the door and effectuated the robbery? Couldn't the jury infer from that a continued participation in the crime?
Couldn't the jury infer that because he had opened the door?
No, because couldn't the jury infer that because your client spoke at some length with the victim during the time that the robbery occurred, that could have been conduct participating in the robbery, namely distracting the victim to allow an opportunity for the co-defendant to rob the victim?
It could have, Judge, but it could have been an innocent explanation as well. It could have been a completely different conversation. It could have been, everything's going well, don't come here.
And doesn't the jury, as the finder of fact, sit in the proper position to weigh those competing inferences?
Yes, they do. There was no content to that phone call, and I will point out that there's a discrepancy in the evidence as to that. Jacob Adams never testified that there was an auditory phone call during the drug transaction, and that phone call would have happened during the drug transaction.
Jacob testified that your client did intend to rob him, correct?
He testified that his understanding when they went out to the car was that there was going to be a robbery, but he also testifies. His testimony interlocks with the defendant's. The defendant told the detectives, when I went out, I initially, and Jacob Adams and the defendant are consistent on this point, he initially refused multiple times to engage in the robbery. He said, this is not a good idea, this is my known drug dealer, this is somebody who sells me marijuana on a regular basis. He then caved in and agreed, and then he took it back. And at the time he took it back, the defendant told the detective, I was outside of the apartment alone with Martaz Sugar. Sounds kind of like a convenient explanation, except that Jacob Adams corroborates that he was at several points that night in the defendant's home on his phone, and the defendant was outside with Martaz Sugar having conversations outside of his presence.
Who was it that testified that when the victim was there and asked by your client to give up his bag, which I assume had cash and drugs and whatever else in it, and the victim actually started to do that, and your client teased him, mocked him, said, you're going to give it up just like that? At which point the victim pulled it back and started fighting, and the next thing you know, Sugar shoots him. Wasn't there testimony in the record to that effect?
There was no testimony of teasing and mocking. Those words aren't used. Those words are never used. That was the state's interpretation, but the defendant told the detective during the robbery, he told the victim, are you just going to give it up like that, in hopes that Martaz Sugar would see resistance and leave? That's what he told.
That's what he said, though.
That's what he told the detective. So the only
next
reason.
thing that happened was Sugar shot him, right?
No. The next thing that happened was the victim began to give the bag to the defendant, and then when that movement occurred, there was, I think the defendant describes a struggle. The victim pulled back, and that's when the shooting occurred.
Your client never tried to notify the victim beforehand to, don't come, I'm going to cancel, nothing else.
No,
correct?
but he didn't have a burden to do that. We don't really have.
He didn't what?
He didn't have a burden to reach out to the victim
I
and
didn't
say.
ask if he had a burden, I asked
No,
if he did.
He didn't, Judge. He
Okay.
didn't. He didn't, and at the time, according to his statement to the police, at the time, he believed that he had canceled this plan with Martaz Sugar.
How was the plan canceled?
Verbally. He told him, I'm not doing this anymore. He said something along the lines of, bro, I don't think I can do this. That's what he said at minute 1:05 and 38 seconds of his statement to the detective.
The cases involving the principal issue, the issue of whether the defendant was a principal in
Yes.
that action, are very fact intense. What's the best case or two, if you have it, that puts the facts of this case into the context of your best case? In other words, what's your best case? If you were to walk up and say, here, Judge, this case is factually similar to this one, and the conviction was reversed in this case. What's your best case?
That would be the case that we cited on our brief on issue 1, where there was a similar robbery where two men were going towards a vehicle to engage in a drug deal. One of them kind of disappeared. The other one was observed committing the robbery, but there was not enough evidence to suggest that there was, as Your Honor pointed out, there's a principles theory, so the requirements are exacting. It has to be, there has to be some act or some word that the defendant says which is meant to and which actually does incite, cause, encourage the other person to commit a crime. And our argument is we don't have that in this case because there's no content for these calls. It
sounds like you're talking about the Rocker case, right? The defendant in that case never even approached the vehicle.
I'm
right?
sorry?
The defendant in the Rocker case never even approached the vehicle. Is that correct?
He was seen walking towards it. And
Was
then
he in the vehicle?
at the moment of the robbery, he wasn't seen. It was the other individual.
And was there any evidence in that case that the defendant had, prior to the robbery, had agreed to participate in the robbery? Was there any evidence of that?
There was evidence because they were having a phone call in the friend's apartment building, and when they were having the phone call to get the drug dealer to go to the location, one of the friends said, the co-defendant said, shush, don't ask why he's
Did the defendant in the Rocker case return to the scene of the crime to clean up evidence?
He didn't. He didn't. And that's something that this defendant did do. He went back to wipe the car down, that's true, but questionable behavior after the fact isn't enough to convict on a principal theory.
I'm sorry, questionable behavior?
Questionable behavior after the fact.
What do you mean by questionable behavior?
Questionable behavior in the sense of trying to wipe down the fingerprints from the vehicle, because he's scared. They're all scared. So they're
Is that
going.
why you went on to social media and showed the marijuana and showed the money? Because he was so scared?
No, I think he testified. He told the detective he was high at that point. He had already smoked more marijuana at that point, and he was pretty fuzzy. Also, there was testimony that the photographs were, the video/photograph was introduced with a certain timestamp, but that doesn't indicate it was taken at that time.
All right, you're into your rebuttal time. I don't know if
Yes.
you want to save it.
Thank you.
Okay.
May it please the court, opposing counsel. My name is Richard Pallas. I represent the state of Florida. And even though we stated originally at the beginning we were focusing on issues 2 and 3, I'll address issue 1 right now. It's my opinion that Rocker, the case that was discussed earlier, is no longer the defendant's best case. I argue that with the change of law, it is their worst case. Rocker cites to the special standard. Had this occurred in 2013, 2019, or possibly 2020 before the month of May when the Florida Supreme Court issued its decision in Bush, then Rocker might be a stronger case for them. Special circumstantial or not, Rocker is still different evidence than what we have here. What we lack in Rocker were Rocker's own statements, aside for telling Butler maybe you want to go take care of something, and Rocker as well trying to purchase drugs from the victim. Here, we actually have the defendant's own statements stating that he eventually agreed to this strong-arm robbery, while we also have him then making a self-serving statement that he repudiated on this agreement. The jury is allowed to take inferences and actually reject that kind of testimony. The credibility with that was the jury's to weigh alone and not the judge's to assess in whether or not to grant this motion for judgment of acquittal. Further, Butler, who was the eyewitness, did not see Rocker involved in that robbery. He only saw Banks. Here we have Mr. Adams's testimony, literally recording this on his phone on a Snapchat app, as well as Mr. Adams himself stating explicitly that the defendant agreed here. And in addition to, of course, all of that, we have the mocking that the defendant had made, saying you're going to give it up like that. But to touch on issue 2, just to make real quick here, the judge went through about 5 pages of transcript, listening to Dr. Kaiser state why he needed these 9 photographs over the other ones that were already stipulated and entered in. This court asked whether or not death was a stipulated issue. Death was not stipulated upon my review of this record. The state had to prove that beyond a reasonable doubt. And to me, this is Old Chief Evidence 101 here. Even when an element is stipulated to, the state is still able to prove its case the way that, in its discretion, it think it best can do so under the rules of evidence. Our standard for Section 9403 rulings is whether or not reasonable jurists could not disagree as to the propriety of this judge's ruling. The judge went through 9 photographs, both in chambers and after listening to the doctor's testimony, and decided that the 3 that were entered were the most appropriate ones, and that then those were shown to describe the perforation that was done to the victim's lungs, to the victim's kidney, and the victim's spleen.
There were, 7 photographs that were agreed upon to be admissible?
That is correct, Your Honor.
And there were 6 that the judge did exclude based on the objection of defendant, correct?
That is correct, Your Honor. We had ones where...
Who other than the state should decide when you have enough proof to meet the beyond a reasonable doubt? I mean, is that up to the judge, the defendant, or to the state?
I mean, here, I believe, Your Honor, it is the state's discretion whether they have enough for reading this reasonable doubt standard. Of course, the judge was able to weigh whether or not they thought that this was enough to get in. Certainly, I think we could have entered more of these photographs, and it still wouldn't have been an abuse of discretion by this judge. But evidentiary rulings are to the discretion of our trial judge in terms of what happened here.
As Judge Pratt mentioned, typically, and I was a trial lawyer for 35 years, typically when you see the person, the entire person, or a person of the face or something like that, that you can easily identify, that's where the potential for real prejudice is. As Judge Pratt mentioned, when you're looking at clinical shots, obviously, evidence of a terrible tragedy, but that's not seeing the person, the face, that's seeing almost a clinical shot. Would you agree with that?
I would agree with that, Your Honor. Yes. That, I think clinical is the perfect word here. I mean, here we are learning objectively how it is that, unfortunately, the victim came to pass. Dr. Kazar stated, you could just enter in my report. He could have just testified. But people are different kind of learners. We have auditory, we have those that read, we have those that are kinesthetic. A picture's worth 1,000 words, and here the doctor was only spent, I believe, 15 pages of transcript holding up those 3 particular photographs.
Counsel, was there any discussion about having a diagram of the various organs that had been injured versus putting in the victim's actual organs, which assuming had been removed from the body for the purpose of the photograph? Was there any discussion going that route? Because that would seem to reduce the prejudice dramatically.
Your Honor, based on my recollection of the record, I honestly could not tell you if I recall there being a diagram discussed in this. I know that it was just that the defense did not want these 9 photographs in. I thought that they were just objected to based on prejudice. Whether that was raised as an alternative, while certainly they could have done that, I still don't think that reaches our threshold here, which is not just relevancy versus prejudice, it's whether that prejudice substantially outweighs the relevance. I agree that certainly a diagram could be relevant, but here actually going through our specific victim and stating how this happened, I think that that is, in my opinion, more relevant than going through a diagram. I think that had that maybe been more presented to the trial court, without knowing at this moment whether that was discussed in the record, Certainly, maybe it would have affected the trial judge's decision, but here again, going on the Kanakeres standard, I don't believe this is something where reasonable jurists would disagree with the trial court's ruling here to, instead of bringing in a diagram showing these organs, instead showing 3 photographs.
Did your research find any case that has allowed these types of photographs of organs into proceedings in Florida?
My research of these specific organs in this specific type of case where we're dealing with felony first-degree murder, I could not give you a case, Your Honor. I can say that the case given by the defense, the Hoffer case, I believe, I mean, that case, there was already error in a jury instruction issue. I mean, that alleviates, or I should say, that made harmless error less of a possibility to be used in that case. I know Hoffer was where, forgive the macabre here, but I believe the scalp was peeled back in that case, showing the face of the victim. Here, we're looking at things in a more clinical perspective. And again, it is the appellant's burden to show error here. So had they shown a case on all fours where we have these 3 organs, only 3 photographs of them being prejudice under the section 90.403, certainly we need to distinguish that case there. While I agree it would be better for me to introduce a case here, I can at least say that the state meets its burden of harmless error, because even if we argue that this was an abuse of discretion to allow these 3 photographs, there's no reasonable possibility this affected the verdict. As I said, this was only 15 pages of transcript in a 15 pages of testimony and a 1,000-page transcript, testimony that I believe at least eclipsed 40 pages or so regarding the medical examiner. And further with this, in terms of how much of that was actually mentioned in the closing arguments by the state, nothing in rebuttal, and I believe just on page maybe 911, there was no talk of what specific photographs, just stating the medical examiner testified, and we introduced photographs showing how it was that the victim died.
What was the nature of the objection at trial?
The nature of the objection, I believe, was unfair prejudice, Your Honor. Okay. And them stating, again, we didn't have any stipulations of death there. We just had them objecting under the typical 403 analysis. And again here, I think that the way that the judge went through this analysis, that shows it ruling within its sound discretion. Had he said, I don't even want to hear the proffered testimony, just let the 9 photographs in, perhaps we have less of an argument here. But that did not happen. We have the judge going through it right here during the proffer, then reviewing the photographs and deciding only 3 of the 9 and explaining why the 3 of the 9 should come in over the other 6, or at least regards to 1 that showed, I believe, was 2 of the sides of the lung instead of just the full lung. But then moving on from that, I know that it was stated at the beginning that issue 3 would be addressed. If this court has any questions on that, I would invite them right now. But if not, I believe we have competent substantial evidence here, especially when we view the factual conflicts in favor of the state and any inferences that we gather from this evidence. So the motion for judgment of acquittal was properly denied here, especially in light of a post-Bush landscape that we find ourselves. And I find that this was not an abuse of discretion in finding that 3 photographs of however many the state could have introduced, that unfair prejudice from that would substantially outweigh the probative value. But if this court has no questions regarding the...
I do have a question or two on the 3rd issue.
Yes, Your Honor.
The first is just the standard of review. I understand the state's position is that even if there are errors in some of the findings made on the sentencing issue, that we are to review for harmless error. Is that the state's position?
Yes, Your Honor.
Okay. And then my second question goes to preservation. I understand that the 1st District has some case law generally holding that there needs to be a contemporaneous objection after the findings are made in order to preserve, an attack on the findings for the sentencing issue. Does the state have a position on that as to what? Because as I understand it, I think your brief just engaged the merits of the issue and didn't, argue that the defendant failed to preserve. But I just wanted to hear from you whether the state has a position on preservation.
Yes, Your Honor. Just to go off it, that is correct. Our brief mostly focused on that this was not an abuse of discretion under the standard of review we have. But I would argue, at least thinking of First District Court of Appeal cases regarding contemporaneous objections, I'm certainly thinking of the recent case law coming out of there regarding the downward departure issues and whether or not such things need to be preserved. I think absent showing harmless error, absent the defense showing fundamental error here, there does need to be a contemporaneous objection. At a minimum, either motions under Rule 9800B1, which can be filed before the notice of appeal, which involves, I believe, a motion for rehearing mechanism, or, of course, B2 motions that can be filed after the notice of appeal has been filed before the initial brief. But in terms of this, had the defense had problems with the actual trial court's weighing of these factors, those could have been brought up on the record. The trial court could have corrected them. The trial court had not yet rendered its written order. It read very close to what that written order's findings ultimately were when it weighed the 10 factors under Section 921, 1401, B2, A through J. In terms of all that, those could have been brought to the court's attention, and the court could have explained, and I believe it is more than implicit in this finding that they weighed the factors of A and B above any other factors that were involved in this particular case, and of which that is well within the court's sound discretion to do so in finding the effect on the community as well as the victims.
Just to make sure I'm hearing you right, the state's position is not preserved, therefore reviewed for fundamental error, and in any event, harmless.
That is
the
correct,
state's
Your
position?
Honor.
Okay.
Yes, Your Honor.
There was no objection, to be clear, correct?
There was no objection.
In the appellant's brief, do they raise that this is fundamental error?
I do not recall that upon my review of the brief. I know, our district is clear with, I think it's the Calabrese case. Even if you raised it later on in the reply brief, that is still not preserved as an issue on appeal. That would be waived. If this court has no other questions, I will rely on the state's briefs, and I ask that you affirm.
All right, thank you very much.
Thank you, Your Honors.
And counsel, if we could just pick up quickly where we left off on the sentencing issue, could you state your succinct position on whether this error is preserved? If not, whether you have sufficiently argued fundamental error in your initial brief?
Judge, the issue of the error not being preserved was never raised by the appellant on appeal. It was not raised as a defense to this claim of error. So there.
Right, but we can sua sponte determine whether or not an issue is properly before us, can we not?
Sure. So the error was not preserved. There was no objection made at trial. But even if the court.
So then would that mean that we review for fundamental error?
I believe so, yes.
Okay, and did you argue
If the
fundamental
court
error?
decides-
Did you argue fundamental error in your initial brief?
No, I don't believe fundamental error was argued in the initial brief because the state never raised it as a defense. So there was nothing to respond to say that this error was fundamental. But the error was fundamental. Even if the court applies that standard, he's entitled to relief, and I can explain why. The court in this case had
Right, but our court's precedent is that allegations of fundamental error must be raised in an initial brief, right? Because if the appellant fails to preserve the issue, then the onus is on the appellant to recognize the lack of preservation and then to argue that we should nonetheless exercise our discretion to correct a fundamental error, right? So, I mean, I don't see how the issue can properly be before us if, as you've conceded, your initial brief does not argue fundamental error, if that's the standard.
I think it's because the appellant never raised that defense. So the court should review the record for fundamental error on that issue. Because in this case,
Is this an Anders brief?
no, it's not.
Well, then, if you don't make a claim that it's fundamental error, how is your opponent supposed to respond to a lack of that claim? You want to raise it in your reply brief, they're done. They don't get a sur rebuttal, sur reply, anything else. I mean, that's our law here is you raise it in your initial brief or you haven't raised it for the appeal. You're familiar with that, aren't you?
I am, but I believe that it's plain from the face of the record that the court made findings that were not supported by competent substantial evidence.
And that's why there was no objection made at trial and you didn't claim it as fundamental error. I don't understand that.
There was no objection made at sentencing. There were written and oral findings that were made. So there was no objection made at sentencing, but it's plain from the face of the record that what the reasoning of the court as to why she was going to impose a life sentence is simply not supported by competent substantial evidence in the record, particularly where the court ascribed.
Well,
the-
counsel, I think they're trying to say you have to raise it in your brief. If you don't do it, it's waived. It's
Okay.
that simple.
Well-
If you would acknowledge that, it would make things move along. You can get your other issues.
Yeah, I will move on. With regard to the photographs that were introduced, the court seems to imply that basically it's a free-for-all to introduce pictures of organs. Again, as Judge McCarr pointed out, there's no case that we have in which organs were introduced because this is not
The
something.
trial judge treated it as a free-for-all, or did the trial judge hear testimony from the medical examiner that those photographs will be helpful to him to explain the cause and manner of death?
But he also testified he didn't need
my
them.
question.
Yes, the judge did, but
How do you describe it as a free-for-all when the judge holds an evidentiary hearing and listens to argument from both sides? How does that turn into a free-for-all?
because, Judge, the photographs were gruesome, they were unnecessary to introduce, that
Necessary is not the standard. You've agreed to
Almeida
that.
says that, but it says that the unnecessary standard does not create a carte blanche for the state to
You're out of time if
introduce.
you want to wrap up very quickly.
Sure. The photographs were gruesome. They're not often introduced in non-capital cases, and that's why there's not cases that discuss multiple photos of multiple organs being shown to the jury. It was a free-for-all, in my opinion, because there was no need to introduce that. The organ is, whether the court believes that the organ photographed inside of the victim is worse, respectfully, we disagree. There's a
thank you very
freestanding
much.
organ that's very frayed. Thank you.
All right, we're going to, y'all find remaining on the bench? Okay, we'll stay here and be at ease while the parties shift around for the next case.